As council probably recognize, we have reviewed the matters filed with us. We've conferenced the case. We've talked about it. I can tell you that we're inclined to exercise our special action jurisdiction. I can't tell you what we're going to do because we haven't made a final decision on that yet. And of course, we want to hear from you. So you don't need to spend time on the jurisdictional issue unless the state has something to bring up that I haven't seen yet. And it's quite possible I could have overlooked something. If each of you, whoever's arguing, will state your name for our unofficial recording, we'd appreciate it. And we have 20 minutes aside, as you know. Having said that, who's going to go first? Mr. Johnson?
Yes, Your Honor. Good morning, Your Honors. Brett Johnson. May it please the Court, Brett Johnson for Psychological Counseling Petitioner, or PCS for short. With me today is Sarah Ogney from Snell and Wilmer, Larry Hammond, Ann Chapman, and Anna Finn for Osborne Maladon, all on behalf of PCS. Your Honors, this case is about a foreign jurisdiction seeking the disclosure of confidential medical records for multiple Arizona patients in violation of well-established Arizona law and case precedent that requires the Arizona trial court to be the gatekeeper and protect and narrow any release of confidential medical records.
I like the idea of the Arizona courts being a gatekeeper, but I don't find that in Tracy.
Yes, Your Honor. Distinguishing Tracy, go right off the bat. Tracy is a privilege case, Your Honor. The law that we brought up before Judge O'Connor is in regard to the confidential medical records laws and the disclosures to third parties, whoever they may be. In this case, Wisconsin, as I believe Judge Howell asked the question during our stay hearing, Wisconsin is considered a third party in this case. Until an Arizona court issues an order, anything outside of Arizona is a third party. Therefore, the disclosure law is applicable, and Tracy is inapplicable to the extent that that dealt with purely with privileges, the privileges during a testimonial evidence. As we pointed out in our papers in this case, Your Honor, there is not going to be testimony in this case.
Well, before we get to the testimony issue, hopefully we can come back to it. Explain to me how the records and testimony, if there is any testimony from the custodian, here are significantly different, as I think you're arguing, from the attorney and accountant privileges that were also at issue in Tracy.
Of course, Your Honor. The attorney-client privilege and the accountant privilege do not have that same statute of dealing with the disclosure of medical records, the HIPAA underpinning, the Arizona law that guides our public policy in regard to disclosing confidential medical records. It's a separate distinction in regard to testimony. Prosecutors in Arizona, defense counsel in Arizona, have to go through the Benton and Bain and Tucson Medical Center analysis. Why would we abdicate that authority to Wisconsin, who does not follow our same jurisdiction?
Well, what interest does Arizona have regarding Wisconsin prosecution? As Tracy points out, the professional privileges aren't constitutionally mandated. Each state can have whatever professional privileges it wants, and the consequence of that is that we must strictly construe those, and they're inimical to the truth-finding process. So we don't look favorably on those statutorily created privileges.
Yes, Your Honor. That goes to the public policy argument that I think actually Tracy and what our argument is actually in harmony together. We're trying to harmonize Bain, Arizona Supreme Court case, with Tracy, Arizona Supreme Court case. One's dealing with the disclosure of medical records, the other one's dealing with privilege. Judge O'Connor declined to review our disclosure argument. The public policy argument behind the statutes is combined. So first we have ARS 133620 that requires all practitioners to report and disclose alleged abuse. That does not mean that there's a automatic waiver of privilege, and Udall, this Udall versus Superior Court is on point on that. The public policy for Arizona, in ARS 322085, that makes the medical practitioner, the mental health practitioner, equivalent to the attorney-client privilege is significant. Why? We want people with mental health issues to disclose everything to their doctors. It's for treatment. Why? Tucson, Aurora, San Francisco, Washington, D.C. We want those mental health patients to get the treatment and avoid harming other people in the community. In this case, our public policy worked. 3620, report was made to Wisconsin, an investigation was done, and a prosecution was initiated. That is the purpose of the Arizona law, and that's the public policy. To get to that point, we needed to give that individual the privileges underneath Arizona law. I think a bigger issue, Your Honor, also is because of the mental health treatment, is there's third-party information that is contained in those records. That is the reason why we needed to have a judge to do in-camera.
The Wisconsin court isn't capable of protecting the third-party information that wouldn't be relevant here.
According to Wisconsin's public policy. But the acts that occurred, the treatment that was provided, the disclosure was all done in regard to Arizona law.
If the Wisconsin court indicated that we are willing to apply Arizona law as it relates to any communications that occurred in Arizona, would it change your argument at all?
I think that's analysis that Judge O'Connor should have done in regard to what law is Wisconsin going to apply, because we care about Arizona public policy. That was not the analysis, and in fact, in the record, what we have is the opposite.
If we did have in the record say that the Wisconsin court said, I will apply Arizona law, would that satisfy your client's concern?
I believe it would. I think that that's also a factual issue that would have to be determined by the trial court, but I think for purposes of comedy, if the foreign jurisdiction said we will apply Arizona law, do an in-camera review, balance against Arizona's public interest and the other third-party patients that are Arizona-based, and then only release narrowly what is required by the state, just like Arizona prosecutors would do and Arizona Defense Counsel would have to do, the narrow information. Why do we need 30 days of medical records in regard to one statement that was made? That is fundamental in our case law as well as our statute, that you don't get all of the medical records.
But what I'm having difficulty with is I don't disagree that as a factual or a policy matter, you may be correct about the disclosure of those particular records. I guess the difficulty I'm having is that Wisconsin is an equal member of the United States, and Wisconsin can have whatever privilege law it wants. It's not constitutionally required to have anything. I don't know why Arizona's privilege takes precedence.
In that context, Your Honor, the Arizona legislature, when it enacted 122094.0, could have made an exemption for the Uniform Act. Or when they enacted the Uniform Act, it would have said, we do not care about all the other disclosure requirements, not the privilege requirements, the disclosure requirements underneath Arizona law. The Arizona legislature did not do that. Instead, we have 22.294.1, which applies to all of the parties. So why would we give Wisconsin better rights and more disclosure rights than we would give to our own prosecutors and our own defense counsel? Public policy in Arizona requires that we protect those mental health care people, all of them, and as I believe it was in the most recent case of Beta, which was by the Court of Appeals just last month, mentioned, once we tell them, please join in therapy, once that happens, we will not let your privilege end up on the heap of trash. That is what the court said a month ago in regard to a Beta and the disclosure of third-party medical records. Your Honor, I see my time. I'm going to now relay the rest of my time to Mr. Pecoretta.
That's fine, and stop the clock for a second, please. I think I forgot to mention that if you want to reserve some for rebuttal, you need to do that.
Right, reserved for it. Apologize, Your Honor.
I figured you knew it, but I should have mentioned it.
Mr. Pecoretta is going to be doing it for me.
Judge, since the questions were on Tracy, I was going to address other issues, but I think the court has to ask itself, when you look at Tracy, it's really about Navajo jurisdiction. There's the discussion about the attorney-client privilege where you have the right testimonially to invoke it there. Then there's about 2 sentences, and I think dollars to donuts that there was no discussion of any of the statutes we've mentioned because they weren't enacted. There was no comprehension at the time, medical confidentiality, medical privileges, psychiatric records. None of those issues were briefed, argued, or decided. And the one case that Tracy cited, they cited a case where the person was raising Maryland privileges in a California grand jury, and what that case said is, wait a minute, guy, the activity, all the actions took place in California, but we're going to analyze it. Anyway, Maryland doesn't apply. This is really, when you get down to it, a conflicts of law issue. And here you have bunches of patients that now, if their records are involved, that the healthcare provider now has to tell them, by the way, we're being turned over to Wisconsin, and I guess if you want to be heard, you need to go to Wisconsin. They take patients from all over the country. They apply Arizona law. And in this case, Tracy never dealt with these issues. I admit they have some language there for 2 sentences, but if you look at the underpinning, the logic, the briefs, it was never considered.
Sometimes when this court suggests that the Supreme Court didn't mean what they said, it doesn't always turn out real well.
Well, all you can do is say, well, now we're looking at statutes that weren't applicable, and here's how we think. But you have to, Tracy's easy to distinguish. But what I want to talk about, here's a problem when you have premature subpoenas go out. As we filed today, the Wisconsin Supreme Court ruled, and they accepted the defendant's motion for reconsideration, and it's a complicated opinion, but basically they affirmed the Court of Appeals opinion precluding the victim, who was non-cooperative in this case, from testifying. So now we're in a position, which we tried to tell the trial court, there may never even be a trial. And that's why if you follow the act, which was not followed at all, these things are usually routine. Here's a subpoena. John Smith, go testify, either an evidentiary hearing, a grand jury, or a trial. Here, because it was premature, the facts kept moving at all times throughout this process.
I'm more willing to defer to the state of Wisconsin and Wisconsin courts if they tell us that they have something pending. That seems to make more sense to me than having Wisconsin courts interpret Arizona law. And if a Wisconsin court is saying, we have something pending, what's up on appeal is something that's going to address an issue that will affect perhaps one type of evidence, but the case is going to go forward, we think it makes sense to do discovery. Why shouldn't we defer to the Wisconsin court?
Well, A, they haven't said that. B, it was an interlocutory appeal. Obviously, testimony of the victim is critical to any case, even an uncooperative victim. And what normally we don't have to delve in all these issues, like is a subpoena for someone to attend and testify. The Wisconsin court has, the case is not pending in the trial court, as the representation was made. It's pending in the Supreme Court. The prosecution is going on, but it's up there.
That's the way it would be if it were here, and we understand that, but we don't know how Wisconsin courts operate, and if their district judge or trial judge says, hey, I've got a case here, I mean, don't we defer to that?
Well, except that you notice in the state's argument, they don't say, the statute says pending in this court. He has never said pending in this court. There's a prosecution there, and we know now it's in the Supreme Court. I suggest that this case is very simple to resolve by saying, you did not comply with the Uniform Act.
Doesn't the act just say that if there is a prosecution pending, a prosecution is pending? I thought it was the language. Isn't something pending in Wisconsin?
Yeah, but the statute doesn't say if something's pending in Wisconsin. It's got to be pending in that court. And that's what the statute says. And to make someone come across the country to attend and testify. And then the court here in Arizona has to decide whether the witness is material and necessary and whether it's an undue
You want us
hardship.
to decide what Wisconsin law is regarding when something is pending in a particular court. That seems like a better determination.
Well, that's part of it.
Wisconsin court.
But you look at what's pending was a status conference. There was nothing to attend and testify. And now we have privileged medical records that are being talked about. They wanted that is a subpoena.
But you're not suggesting we have to wait until there's actually a trial date, though. Presumably records are something that you would want to address during discovery prior to trial.
Well, they have, under the Act, if there's a grand jury or an evidentiary hearing, something going on. I don't think that, just like in Arizona, we don't have discovery from the judge call up and say, hey, by the way, drop off your records. Normally, there's a subpoena issued. But this isn't like Phoenix going to Mesa. This is go all the way to Wisconsin. And if the original order had not been stayed, you have a custodian of record traveling 3,000 miles with clearly overbroad subpoena. When you read the subpoena, it wants everything included but not limited to, which is one of the issues that needed to be addressed here.
But let's say we took care of that issue. Assume we were to agree with your position that our court needs to make a determination before privileged documents can be turned over. Is there still the concern, can't the documents just be sent over? Does the custodian records need to go with them? Is that still an issue?
Well, yeah, because for privileged medical records, especially records containing information about other patients, particularly records that might be beyond what the law permits them to release, I think PCS is going to be required.
But that's what if we're suggesting, that if this court were to, or if Arizona was to decide that we're going to review these records, our courts are going to review these records before they can go anywhere. So we've made the determination about whether anything needs to be redacted or other people's records need to be separated. At that point, is it a significant concern when the person has to go to Wisconsin, the custodian of records?
Yeah, I think that would be a decision PCS would make. If I was cautious, I would recommend to them, still don't mail people's records until because the Wisconsin court then has to make their Wisconsin determination. I wanted to reserve 4 minutes, and as usual, I got tied up on other things, but that's our position when you have an overbroad subpoena, and this is why you wait until there's actually something there. And in this case, there may never be something there based on today's ruling.
Thank you very much.
May it please the court, my name is Catherine Leash, and I represent the state of Arizona on behalf of the state of Wisconsin. In lieu of both petitioners' arguments, I'd like to take this discussion back to what it's really concerning, and that is the Uniform Act on out-of-state witnesses. The Uniform Act is not under consideration in any of the cases that petitioners reference, for example, Miles, Wilson, and Bain. Those are all cases in which an Arizona court is applying Arizona law to Arizona cases.
Pardon me for interrupting, but do you agree that some sort of redacting or some sort of analysis would be done before the records would be turned over if this were an Arizona prosecution?
If it were an Arizona prosecution, I would...
Prosecution be entitled to all the records that Wisconsin is seeking?
I think it would go to an in-camera review, and I don't think the state would object to that. But in this case...
Why shouldn't we do that here?
Because it isn't Arizona law that applies, and Tracy's very clear about that.
The communications occurred in Arizona.
Again, that happened in Tracy as well. And Tracy said, look, because they're not constitutional rights, because they're simply state statute, then the Navajo Nation applies the privileges there.
What if in this case Wisconsin says we're not going to honor any of the privileges that Arizona has, or the confidentiality requirements that Arizona has enacted? Do we not have an obligation to enforce those provisions that our legislature has enacted?
No, because
why not?
because this case is not pending in Arizona. And
but
again,
isn't the purpose of the statute don't we enact a statute to encourage, say, the psychiatrist's privilege because we want to encourage people in Arizona to go and get counseling in Arizona, isn't that something that the Arizona legislature has an interest in? Isn't there a public policy reason underlying that statute?
Well, there is a public policy reason under the Arizona statutes, although I'd like to call the court's attention both to ARS 122294 and ARS 122294.01, both of which say if there's a court order, you turn the records over. And there is a court order in this case. There's a subpoena. So right there, we have addressed the privilege that they're claiming under
They
those
also have an
statutes.
obligation to assert a privilege on behalf of their patient, do they not?
They do, but again, the Arizona court would review that for the Arizona case in camera, which the Wisconsin court has also said it would do. But in addition to that, we also have the statutes 133620, which petitioners kind of gloss over, and it is section P, not the beginning section, but down in the definitions for the purpose of this statute. And petitioners kind of glossed over P4, which says any offense listed in chapters 14 or in the case of incest are not protected.
But
And there is no dispute in this.
there's still protected information that are part of those records. The state doesn't get anything relating to the defendant's, or doesn't get everything related to the defendant's mental health or third-party information just because there's a specific crime due. That some of this information would not be admissible or discoverable in Arizona, I'm assuming.
That is
that not
true.
accurate?
But again, that would go back to an in-camera review. Petitioners would turn
Okay,
the records
but if
over.
we agree that there should be an in-camera review, I guess the question for me is, should that in-camera review take place in Arizona or Wisconsin?
It should take place in the state where the disclosure itself is actually occurring.
But why doesn't it
and
make sense to say it should take place in the state where the activity occurred, where the communications occurred? If we have an interest in creating privileges or confidentiality requirements, why shouldn't our courts be the one to make that determination?
Our court doesn't have an interest in making privileges that apply to proceedings in other state. That is, and again, I go back to Tracy. That's what Tracy said. And Tracy addressed professional privileges.
But would you agree that some privileges perhaps are more significant than others, and maybe confidential medical records may be something that's different than the accountant privilege, whatever that might be?
They cannot possibly be more important than the attorney-client privilege. There is a case, Bain, for example, that says psychological patient protections are equal to attorney-client privileges. However, 3620 says, no, psychological medical doctors are required to report, which is something an attorney does not have to do. And they're also required to turn over records, which an attorney would never have to do. So the fact is the psychological patient privilege is actually more limited than the attorney-client privilege, and Tracy said, we won't apply our attorney-client privilege to the Navajo Nation.
I believe Mr. Picaretta pointed out, isn't the only case that the Arizona Supreme Court referenced was one where really the only issue was, does Maryland law apply or does California law apply? And in that case, the communications at issue took place in California, so the Maryland court simply said, California law applies, so you don't get to take advantage of the Maryland Shield law.
I think our Supreme Court was probably a little more sophisticated than that when they made their ruling. They may have discussed those cases, but their ruling was both accountant privilege and, most importantly, attorney-client privilege is determined by the requesting jurisdiction. And it is, frankly, our scheme of laws is a balancing one. And I would certainly agree that, for example, PCS's position that in a group meeting for treatment, third-party information should not be permitted if they're in Arizona. I'm not an expert on Wisconsin law. I don't know what their privileges say. However-
Isn't that really part of the problem here, in that we have these privileges in Arizona for our people here in Arizona, and this law and the way that both states are seeking to apply it wipes all that out.
I don't think so.
Well, we don't even know, I mean, do you know what Wisconsin law is on all of these privileges and nuances? I don't.
As I said, no, I do not. However, I would point out two things to the court about petitioner's argument. First of all, if they believe that Wisconsin law would constitute an egregious violation of their rights over and above what Tracy covers, obviously they could have brought that to the court's attention, and they have never claimed that their Arizona privileges would be violated under Arizona or under Wisconsin law by telling us what Wisconsin law is. That is their burden, because we have got a prima facie case under the out-of-state witness
But isn't the mere fact that they
statute.
have to turn over records that they would not have to turn over if this were an Arizona proceeding? Doesn't that demonstrate that the Wisconsin may not be applying the law in the same way that an Arizona court might apply it?
Well, I suppose that may be a deduction they'd like you to make, but they still haven't shown anything. They presented no evidence. But
If I could just switch gears for just a minute, my rather limited research, primarily Judge Gemmel's research, there seem to be other states that go through this analysis before sending the cases over to another state. There's a recent case out of New York where the New York court says, well, we're going to apply New York privilege first. They actually come to a different conclusion than the Maryland case, but it's a reporter shield law case. And New York says, well, we're going to, and they're part of, they're signers on the Uniform Act. But if Arizona asks for a witness in New York is going to go through this analysis, and the New York courts are going to apply New York law and do whatever redacting needs to be done, and then send the documents to Arizona. Why should we just send all of our stuff to New York if they request it without doing the same thing?
because the New York law has absolutely no relation to this proceeding. And the reason is, what New York said was, we have passed a journalist First Amendment privilege shield law. It's a constitutional law. So as far as a journalist exercising a First Amendment right of the press, of speech, whatever, New York has determined, constitutionally speaking, that privilege is protected.
Well, why couldn't we make that decision rather than New York?
Well, because the legislature in this state has never said the privilege law for physician-patient is overriding any other interest, including the Out-of-State Witness Act. That's not a policy in this state, and it's not a statute in this state, and it's not even the same subject. It is constitutional, whereas these clearly are not. So,
I'm sorry. Please finish your thought, and then you'll ask my question.
all right, what I was going to say was there are two other cases in which states say that the privilege in that state should be applied before records are sent to the requesting state. The first is, I believe, Marcy, and that's out of, I believe, Michigan. And Marcy does say exactly that we will apply our privilege before we send the records over. Marcy is an anomaly. Marcy is far out of the mainstream when it comes to the interpretation of the out-of-state witness law. And I would also like to point out...
If I could, sorry to interrupt, but what's the state of Arizona's interest in, I understand Wisconsin may have an interest, but it's what's the state of Arizona's interest other than saying we want to be part of this act, but don't we also want to protect Arizona residents under the whatever privileges and confidentiality statutes that have been adopted in Arizona? Why doesn't the state of Arizona have an interest in enforcing Arizona law before sending documents over to another state?
Well, because the Uniform Act says, and Tracy says, this act is intended to provide reciprocal cooperation among jurisdictions. And uniform acts, of course, are intended to be interpreted uniformly. They aren't always, I will grant you. Marcy does not agree and does take your reasoning. However, if the state of Arizona wants to receive reciprocal cooperation from other states on bringing back witnesses from another jurisdiction
Let me just-
for its prosecution.
Let me ask, though, do you agree that if Arizona wants to bring in a witness from another state, would we apply, and some communications took place in the other state, would we apply the law of that state, or would we apply Arizona law?
I think a correct reading of Tracy says we would apply the Arizona law.
Where do you get that from, Tracy?
Because Tracy says, if
Doesn't
you
it
wanna-
just leave the decision to the foreign jurisdiction? But does Tracy go so far as to say the law of the Navajo Nation will apply as opposed to the law of Arizona?
Yes, I believe it does, and that was exactly what Judge Howe was saying, was that Tracy does say, because these are not constitutional privileges, they are not protected by the state of Arizona.
Doesn't it just leave to the Navajo Nation the determination? Does it go as far as to say, we don't care if the Navajo Nation says that Arizona law doesn't apply?
I think basically it does, yes, because it discusses, some of the petitioners in that case were saying, well, some of them were professional privileges, and the court
But
said...
Isn't the only case they cite, though, is the one from Maryland that specifically says that Maryland law doesn't apply to communications that took place in California. That's the only case that Tracy cites for that proposition.
Well, that may be, but that's not Tracy's conclusion. Tracy is very clear that if the Navajo Nation chose to disregard one of the defendants in that proceeding First Amendment rights, that defendant had the same right as any other person would have in Arizona or the Navajo Nation to file petitions for habeas corpus or whatever one would do to protect one's First Amendment rights. It also said Arizona is no better at figuring out what a privilege should be for these professional privileges. So these are entirely two different things. And I think Tracy is very clear that professional privileges are not applied by Arizona before these records are sent. I think it's very clear on that case.
What about the, I think you had something you were going to ask.
Well,
I'm sorry.
Counsel,
Sorry to-
I understand the privilege argument. Are there other disclosure requirements or prohibitions on disclosure to state or federal law that a court would also have to consider, or to state it, I guess, rather, are there other laws that PCS has to be mindful of when it discloses medical records?
Well, sure. But first of all, Tracy says, the Navajo Nation, the other jurisdiction is perfectly qualified to decide what privilege should apply. In addition to that, if there are federal laws protecting more than, for example, what the 122294 or 1222-9401, if there are federal laws that are stricter than that, again, Wisconsin is perfectly capable of applying those laws. And if the petitioners think the Wisconsin law is wrong, or that the Wisconsin decision of the judge is wrong, they have a remedy in federal court if Wisconsin is violating their federal rights.
What is in the record, if anything, about what this judge may have said he is going to do in terms of Wisconsin law or Arizona law?
I don't believe he's said, but I believe he is entitled to apply Wisconsin law. But again, he has also stated specifically that he will accept the records, which, by the way, do not have to be taken by the custodian if it's inconvenient for the custodian.
Well,
I understand they may want to.
Let me ask you about that point, and we're running out of time, so I'm cutting you off a little bit.
Oh, we have 3
I apologize,
minutes.
but this notion of sending the records through the mail or by themselves or by FedEx or armored car or whatever, I don't read the Uniform Act that way. The Uniform Act says attend and testify.
Are you saying that you don't believe the Uniform Act includes a subpoena ducis tecum?
I'm saying I don't think the Uniform Act applies to documents alone.
Well, I believe you're wrong, Judge, and there are many, many cases saying.
Time today.
I would be happy to cite 3 cases,
Amen.
obviously not from Arizona.
It wouldn't be the first time.
Well, it certainly wouldn't for me either, but I won't go into that. But if the court is interested, I've got 3 cases right here that say it is completely illogical to say a state can subpoena a witness but cannot, under the out-of-state witness law, also subpoena that custodian to bring records.
Well, I think I've gotten over the hump of documents, of the fact that documents aren't even mentioned in the Uniform Act.
Okay.
But if we're talking about just sending records,
They don't have.
That doesn't make a lot of sense to me. If somebody's going to testify and they need records to help them testify, that's one thing.
Well, and
That
they
does
may
make
very
sense.
well for the trial, but as Judge Catani pointed out, these things are actually pretrial discovery matters.
So Wisconsin wants the custodian to come and give a custodian of records deposition to the court? I mean, it just seems premature to me.
Well, no, Wisconsin wants those records as pretrial discovery. However, they've been subpoenaed by the Wisconsin judge. The Wisconsin judge has said he will conduct an in-camera review.
Oh, he has said that much.
Right, now, yes, he has. We, obviously, neither the state of Arizona nor the state of Wisconsin has any interest in whether the custodian goes or whether they simply send the records. If they want to send the custodian, that's fine. However, what they're claiming is, well, this is really inconvenient for us to send a custodian on this day when there's not a trial. But that is their choice. They can send a custodian. That custodian actually could testify if he wished to, and if Mr. Johnson's attorneys, which believe me he has many of, in Wisconsin, requested that the judge conduct a hearing, or the state did, providing foundation for these records. The court has also indicated it's willing to do that on that day.
If I have one last question regarding the records regarding group therapy with other patients, would the Arizona court go through those records to redact the third party records, or is it the state's view that that's up to Wisconsin to take care of?
Well, I'm bound to tell you, Your Honor, I am out of time.
Please.
Can I answer? Okay. I would argue, and in fact I do argue, that the Uniform Act on out-of-state witnesses is no different in its application than, say, the Uniform Act on detainers or the Uniform Act on extradition. And what those say is, if the other state has provided us with the appropriate documentation, that is, that they have a valid warrant and that this is the guy they want, Arizona doesn't conduct a mini probable cause hearing or trial to determine whether that guy should have to be extradited. It's the same thing here. We've got the right documentation. There's no question that it's been rebutted, and therefore the state leaves to the Wisconsin court the application of privilege.
What you just said, there's no question it's been rebutted. You're referring to the prima facie.
Exactly.
Okay. I just want to make sure I understood. All right. Thank you very much.
Thank you, Your Honors.
Judge, what we do have in the record is a letter from the judge indicating, and it's in Appendix 15, that what he is going to do is apply, if it's relevant and compliant with Wisconsin evidentiary rules, it is admissible at the trial. That's what's in the record, what the judge in Wisconsin said. First of all, this isn't a subpoena from the judge. This is a prosecution subpoena that asks for all of the gentleman's medical records from soup to nuts.
I take it, though, that the Wisconsin judge approved that subpoena, and
He's-
that it otherwise complies with the requirements of the Uniform Act.
Well, he certified it, but his certification was an error, and I'm not accusing him of intentionally, but he indicated the case was pending in his court.
Well, but I'm something interested in telling the Wisconsin judge, you don't understand Wisconsin law. There really isn't a hearing, even though you think there is.
Well, I don't think you have to say that, other than where we stand now, this trial, this hearing may never occur. And that's the problem, is that everyone sort of jumped the gun, and now we're having to deal with this whole mess here that normally judges like you or the trial court don't have to. And this,
But counsel, isn't it up to Wisconsin to figure out whether the gun has been jumped, and shouldn't you be making that argument to the Wisconsin judge and not to us?
well, except Arizona has a role. Arizona's job is not to just rubber stamp what you get. Arizona's role is to determine, is it material and necessary, and would producing these things become an undue hardship? That puts the burden on the courts here to analyze whatever objections are made that they haven't conformed with the act, which we believe it's pretty obvious they haven't. And so in your role in reviewing the findings of, is this witness material and necessary to attend and testify? The answer is no. Would it cause an undue hardship to bring these records for some proceeding where we're claiming that there's no jurisdiction, and to bring all of these records there, and we claim that's an undue hardship under these circumstances? Finally, they talk about private rights of action. There is no private cause of action for a HIPAA violation. And finally, Judge McMurdy, I think if you want to see how this case should get handled, when it went to Judge McMurdy, he gathered all the records, had these people delete all the things that they believed were not relevant, not material, not necessary, submitted to him. He said he spent many hours going through them, and then when we came to court, the trial got vacated and said, well, there's nothing for me to send the witness back to, records back. And then nothing happens for a while, and now we just have a different judge. But that's part of our collateral estoppel argument. Now, we're not saying they're barred forever. If they actually get a trial date and they file it, and it's or a evidentiary hearing date or a grand jury date for a witness to attend, testify, bring records, and the court below does what it's supposed to under Arizona law, the ruling today doesn't permanently bar them. All we're saying is Judge McMurdy dealt with the identical issue. If this case had gone back to Judge McMurdy, presumably he would have done the same thing, and maybe they would have taken it up to the Court of Appeals. But they chose not to, and they agreed with Judge McMurdy he was doing the right thing. The North Carolina court that dealt with this issue wouldn't send the witness back, and even the Wisconsin trial judge on the record said he agreed with the North Carolina judge that since there wasn't a trial, there was nothing to come back for. So the record is confusing, but it's confusion of their own creation.
I gather that neither PCS nor Mr. Johnson, either of the petitioners, has pushed this issue that I had some interest in of sending documents by themselves. That's not a big issue to you.
Well, it is an issue because they've said that we're not going to do it, so they never addressed the issue as requested from the prosecutor. Just mail me everything. Mail it to the prosecutor, by the way, is what his subpoena was. So that would be an issue if they were thinking of doing it, but they we believe there's no authority to do it. And
I realize I'm asking Mr. Johnson's lawyer this question, but is the custodian of records a true custodian in the sense of sort of an office manager type of person, or is it one of the doctors?
I believe they're not going to send one of the doctors, but they're going to send actually the head of the entity, because this is an important issue. They have clients from all over the United States, and they normally don't look at each 50 states when they're trying to figure out the law of confidentiality and privilege. They look to our legislature.
Thank you very much. We'll take the matter under advisement. Let's go off the clock. Before you go, though, Ms. Leach and Mr. Johnson and Mr. Picaretta, is there any urgency, as in this week or next week, to a decision?
No, I can't say that there is.
No, and
Okay, and our stay remains in effect until we say otherwise.
if new developments come in, like the case gets dismissed, we'll of course advise the court.
Please do. We'll take this matter under advisement. We'll be in recess for the next case to come forward and get ready. Thank you.
I'm still telling you, we won't get much in this. As a whole.